Friends, in our previous video we have discussed very important judgment, that is judgment of SMST estates. In this video we are discussing other important judgment, that is NN Global Mercantile Private Limited versus Indo Unique Flame Limited and others. In this judgment, Honorable Supreme Court overruled the SMST estate judgment and other subsequent judgment, that is Garware Waldorf Limited judgment. In this judgment, NN Global judgment, Honorable Supreme Court overruled two judgment, that is SMST estate and Garware Waldorf. In this judgment, Honorable Supreme Court held that the judgment in SMST estate was passed on an application filed under Section 11 of the Arbitration Act for reference of dispute to arbitration prior to amendment in Arbitration and Conciliation Act. After amendment, what happened? Subsection 6A had been included in Section 11 of the Arbitration and Conciliation Act. Before the amendment, what was the law? As held in judgment of SBP and Company versus Patel Engineering Limited. This is very important judgment of Honorable Supreme Court. Till the amendment, that judgment is valid judgment, and at the time of decision of petition under Section 11, court follows the law laid down in the judgment of SVP versus Patel Engineering. What was the law prior to amendment? An application under Section 11(6), the court may determine certain threshold issues. Court will see some important issue, that was whether the claim was time barred, a stale claim, or whether there had been accord and satisfaction which would preclude the necessity of reference to arbitration. This was the law. Court will see this limited issue, and if satisfied, then matter will be referred to arbitration. The issue whether an arbitration clause in a document agreement convey which requires compulsorily to be stamped under the relevant Stamp Act but is now not duly stamped would be enforceable after the insertion of clause 6A. This issue arose in Garware Waldorf Limited. This is also judgment of Honorable Supreme Court, where the issue of amended Section 6A, Section 11 dealt with by the Honorable Supreme Court in the Garware Waldorf Limited judgment. The deficient stamp duty was the main issue before the Supreme Court in SMST estate. Here, Supreme Court considered whether after there was any effect after insertion of subsection 6A in the Section 11 of Arbitration and Conciliation Act. Supreme Court held in Garware Waldorf Limited judgment, arbitration clause in an agreement which is unstamped. If any arbitration clause in an agreement and which is unstamped, it is enjoined by the provision of a Stamp Act to first impound the agreement or conveyance and see that a stamp duty and penalty is paid before agreement as a whole can be acted upon. As per Garware judgment, first of all, court will see whether the agreement is sufficiently stamped. If any deficiency, whether the deficient stamp duty has been paid, along with penalty or not. Only after that, only then the court will act upon the arbitration agreement. But it is important to remember that Stamp Act applies to agreement or conveyance as a whole. As per Supreme Court, a Stamp Act applies on the whole judgment. So, the arbitration agreement cannot be bifurcated for the purpose of referring the arbitration to referring the dispute to the arbitration. Therefore, it is not possible to bifurcate the arbitration clause contained in such agreement or conveyance so as to give the independent existence as has been contended for by the respondent. The independent existence that could be given for certain limited purpose. As per Garber judgment, the independent existence of arbitration clause may be relied for some limited purpose regarding matter may be referred to arbitration. Means the arbitration, if any agreement which is deficient stamp duty, that agreement may be referred to arbitration, that dispute may be referred to arbitration for decision, but arbitrator will decide the right and liability of parties only after fulfilling the after paying the deficient stamp duty along with penalty. Means for the limited purpose regarding referring the matter to arbitration, the independent existence of arbitration agreement may be relied even if the stamp duty is deficient in any agreement. It is clear, therefore, that the introduction of section 11(6)(a) does not in any manner deal with or get over the basis of judgment of SMST estate, which continues to apply even after amendment of section 11(6)(a). Means SMST estate judgment still applies after the amendment in section 11, means after insertion of subsection 6a in section 11 of Arbitration and Conciliation Act. As per Honorable Supreme Court, there is no legal impediment to the enforceability of the arbitration agreement pending payment of stamp duty on substantive contract. The adjudication of rights and obligations under the work order or the substantive commercial contract would, however, not proceed before complying with the mandatory provision of the Stamp Act. Means before the deciding right and liability of the parties, there must be agreement must be sufficiently stamped. Means aggrieved party should pay the deficient stamp duty along with penalty. Only then arbitrator will decide the rights and liability, means decide the petition on merit claim of the parties. In NN Global Judgment, Honorable Supreme Court overruled SMST estate and also Garber judgment. What Supreme Court said that in our view, the decision of SMST estate does not lay down the correct position in law on two issues. First issue is that arbitration agreement is an unstamped commercial contract, cannot be acted upon or is rendered unenforceable in law. Other is arbitration agreement would be invalid where the contract or instrument is voidable at the option of party, such as under section 19 of the Indian Contract Act. In this judgment, Supreme Court held that since the arbitration agreement is independent agreement between the parties and is not chargeable to payment of a stamp duty, the non-payment of a stamp duty on commercial contract would not invalidate the arbitration clause and render it unenforceable since it has an independent existence of its own. The view taken by court on the issue of separability of the arbitration clause on the registration of the substantive contract ought to have been followed even with respect to a stamp act. The non-payment of a stamp duty on the substantive contract would not invalidate even the main contract. It is a deficiency which is curable on the payment of the requisite stamp duty. The second issue in SMST state that violable contract would not be arbitrable as it affects the validity of arbitration agreement is in our view not the correct position in law. The allegation made by party that the substantive contract has been obtained by coercion, fraud, or misrepresentation has to be proved by leading evidence on the issue. These issues can be certainly be adjudicated through arbitration. In this judgment, Honorable Supreme Court overruled the judgment of SMST state with respect to aforesaid two issue as not laying down the correct position of law. Thereafter, the Garware judgment has followed the judgment in SMST state. Therefore, this is also erroneous and does not lay down the correct position in law. We have already held the arbitration agreement is distinct and independent from the underlying substantive commercial contract. Once the arbitration agreement is held to have an independent existence, it can be acted upon irrespective of alleged invalidity of the commercial contract. Honorable Supreme Court in this case overruled the SMST state judgment and Garware Wallstop judgment. But what happened after this judgment? In one more judgment, that is Vidya Drolia judgment, in which judgment the Honorable Court suggested to refer the judgment of NL Global to the higher bench, and thereafter the higher bench, constitutional bench of Honorable Supreme Court, 5 judges bench, decided the referred judgment, and there is majority of 3-2 and passed the judgment 3-2 majority, and that judgment again said that SMST state judgment is good law, Garware Wallstop is good law. So we will discuss in other video, that is recent judgment of NN Global, that is judgment passed by Honorable Supreme Court in 2023. Friends, if you think this video is informative, please like and subscribe my channel. We will meet in our next video. Thank you.